Okay, well, we're in here again and we're talking again about bankruptcy exemptions, and I'm real sorry that we have to keep going over this, but there are just a few people in the class that tend to struggle with this, so I'm going to shut my phone off so we don't get any interruptions. Big thing on this, like I said, and this isn't really that good, but trying to make a point here. 522 D1 is the federal exemption, but in Indiana this is not available, okay? The only exemption in Indiana is the Indiana Code exemption. This is important because many of you, when you submit this form, you just go la-da-da-da-da, put in the federal exemption, just print off the form the way it is in the computer and send it on to me. That's no good. Bankruptcy courts in Indiana will not accept that. And matter of fact, if you make a habit of doing it, it's going to be a problem for your firm. So you need to cure yourself of this right away, and it's why I'm talking about it. Now, like I said, the most important exemption is the homestead exemption. The Indiana exemption now is running close to $30,000 for a couple. It's around $15,000 for individual. So that's something to keep in mind. There's also other areas of exemption. This can be on other real estate. It can be on personal property. But these are much smaller. So, a little bit of cash, few personal items, and a part of a home is all you're really entitled to. $30,000, you're not getting much home for $30,000, although there are homes like that available in Indiana, and but it's a big come down for people that are used to having a $250,000 home to file a liquidation and bankruptcy and end up living in a little, $30,000 cottage inside the main part of town instead of these fancy suburbs. So it can be a big issue, and Indiana is not very kind to debtors, so that's something that you need to keep in mind. Okay, so basically ignore the federal exemptions in Indiana, and you want to look then at other options. Basically states can opt out according to Congress, and Indiana chose to opt out, so that's the big problem. Important thing, and it's been something I've been seeing in some of your assignments that you're just not doing right, and it's just a few points. It's not a big deal, but it is something that I want to emphasize, and that is the importance of the words fresh start. Okay, that's the whole mission of bankruptcy, is to give debtors a fresh start, okay? Things happen, they're young, they made mistakes, or they got real sick, whatever their reasons are, they were required to file bankruptcy. And a lot of people just have an attitude that, well, anybody who files bankruptcy, they're a bad person, and that's not true. The majority of cases I ever saw were people with medical problems, loss of employment, totally unplanned events that just pushed them over the edge. So that's something to keep in mind. So as you're looking at Chapter 9, then keep in mind that the exemptions are a big part of this. You've got to follow the Indiana exemptions. Do not try to opt for the federal exemptions. You cannot do that. Indiana has opted out of federal exemptions. Another thing is dismissal. There's a bunch of different ways that a dismissal can happen. Dismissal can be voluntary. Let's explain, circumstances change. In other words, you're sick, you lost your job, you had to file bankruptcy, and suddenly you win the lottery, okay? Well, it might be possible to dismiss that bankruptcy and work out separate arrangements with all your creditors. In fact, I've actually seen that happen. There's also situations, though, if you don't handle it right and you don't time it right, then the trustee can swoop in and grab that lottery ticket, and then they in turn can make the decisions. Are we taking all the cash now? Are we going to take payments? They may make decisions that are what you don't think are in your best interest. So it can be a bad situation for people. Another area that I've actually seen some people win the lottery while they were in the process of bankruptcy. Another time, estates where a relative died, person was able to clean up all their debts and dismiss their bankruptcy. Court's not necessarily going to let you dismiss your bankruptcy unless you have some kind of a plan worked out that you're going to net out and you're going to come out okay. Another thing is what we call an involuntary dismissal. Sometimes the court gets frustrated because the debtor doesn't do what the court tells them to do in terms of file their taxes, give their tax returns to the trustee, give the refund check to the trustee. There's a number of things like that can happen. And that can be very adverse because you lose the protection of the stay, the automatic stay in the bankruptcy, and now the sharks are after you. They want everything you've got. So involuntary dismissal can be a very bad thing to happen to a person. Another one that we talk about sometimes is conversion. You can be in Chapter 7. The court may require you to go into Chapter 11 because you have too much debt, too many assets, or you can be in Chapter 13 and you got a plan and suddenly something else bad happens and then you have to convert from a 13 to a 7. So it is possible to convert from one chapter to another. But again, it has to be based upon some change in your circumstances. So a lot of times, if you don't cooperate with the trustee, if you don't cooperate with the bankruptcy court, you can have an involuntary dismissal of your bankruptcy. That can be very bad for you, and you don't really want to have that happen. The other item is the conversion, and you can convert one way or another. You can convert from 7 to 13, 7 to 11, 11 to 7, 13 to 7. So you can go back and forth between the chapters depending on changes in your circumstances. Here again, the court has to approve that, and if they see, well, yeah, this makes sense, then they'll probably let you do it. On the other hand, if they say, well, why didn't you do that in the first place? Or, they can ask questions. They can question, well, why is this necessary? So that's another important consideration. Debtors need to be aware that the trustee, examines everything. So in other words, they look at your returns, they look at your work history, look at your doctor bills, they can actually talk to people. They can, cause problems for you if they don't think you're being honest. They can also kind of take over a lot of your assets, the operation of a small business, for example. So it's one of those things you've got to be very careful about, and it can be one of the negative points about being involved in bankruptcy. Another important term that we need to look at is that term reaffirmation. Reaffirmation. What that is, that's a good term for most people. You can selectively choose to repay certain debts in Chapter 7. So you choose to repay. Now, why would you do that? Well, you need your car to go to work. You need a house to live in, and your exemption isn't going to be enough. So basically, it's where you work out a payment plan. You might get to reduce your percentage interest, because the interest rate's been dropping. You might lower your payments by, stretching out the payment period. Let's say that you're on a 20-year mortgage right now, and you push it to 30. so that would lower your payments, and then maybe opt for a lower interest rate. Banks don't want to own real estate. Banks don't want to own cars. Banks don't want to have a bunch of cars lined up out in their parking lot. They want payments. They want interest. That's what they're in the business to do, is charge interest and get paid interest. So if they need to charge you a little bit less interest, but they still are making money, then they're liable to go with you on a reaffirmation. So reaffirmation, very important. Another thing on reaffirmation to keep in mind, this is all covered under 524. So you want to look at that. You can look at that in the United States Code, Section 11, US 524. So very important area. People get some of the terms mixed up. They don't understand the importance of reaffirmation. So here again, you know, that is an important one. It's more important than some other ones you might read about, where you can work out agreements with a whole large group of people. Those are more rare. Most of the time it's reaffirmation, so I would really emphasize that when you're looking at the tests and the quizzes and so forth, that is a much more important word than some of those other ones you might see on the test as a choice, let's say on a multiple choice test. So I cannot say enough about the importance of reaffirmation. You see this in just almost every bankruptcy, especially in Indiana, because it's the only way you can keep your house or your car. You just don't have a big enough exemption to take care of those things. And if you still have secured debt on these items, you're going to have to work out some kind of an agreement. Okay, well, I think that's basically going to be it for today. I hope that you are coming along nicely. From what I'm seeing, things are going along pretty well. Look here for some additional comments from me on a later date regarding future chapters in your bankruptcy textbook. Okay, well, good luck to you. Stay in touch. Thanks.